Good afternoon. It is afternoon now, 12:01 by my time. I hope everybody's doing well. Early happy Thanksgiving, happy holidays, all of that stuff. My name is Jason Hanford. I'm an attorney at Chartwell Law, and we are today presenting to you what is the fourth in our series of overview of Pennsylvania workers' compensation law. This is a section entitled Mitigating Indemnity Exposure, a fancy term for wage loss exposure. It's how to deal with wage loss exposure in Pennsylvania workers' compensation claims. This presentation is being recorded for those who are watching live. It'll be put on our website, as with all the prior sessions in this series of seminars. And if you want to watch there, you can go on our YouTube page, our ever popular YouTube page, throw out some likes, and we'll probably be emailing it around to the participants as well. Just as a housekeeping matter, our next seminar is January 20th, 2022, where instead of mitigating wage loss exposure, we're going to talk about mitigating medical exposure. I don't have a clever title for it, but yeah. It's the title is much less interesting than the actual topic. Medical exposure can be wild. So if you have any problems with medical exposure on your claims, I encourage you to consider that next session. So just basic instructions. If you have any questions while we're giving our presentation, we love questions. We want to be as interactive as possible. It's much more fun and entertaining for you and for us to address your actual questions than for me to just stare at this camera and make bad jokes. So if you have questions, you'll want to go to the bottom of your Zoom window, and there should be a section that says Q&A. In that Q&A, you're going to put your Q, which is your question, and we'll give you the answers. If we can't get to all the questions, we'll make sure to track them and email you or call you with our responses. If you have a question that's sensitive, you don't want to sound dumb, you don't want to, tip anything off, you can certainly email us separate and apart or call us separate and apart from this seminar. Our contact information will be displayed. If it's not being displayed right now, it'll be displayed at the end. As I always say with these things, although we are diligent and hardworking and for the most part, my colleagues more so than I, perhaps intelligent attorneys who know Pennsylvania workers' compensation law, we're not giving you specific legal advice today. So don't go out and make bad decisions based on something you thought you heard us say. Just follow up with us specifically, and we can talk over your specific claims. All that fun stuff out of the way, I want to introduce my two co-panelists. I'll start with Lisa Cavallero. Lisa's from our Philadelphia office. She's been an important partner at Chartwell for a long time. She's done a great job on speaking engagements in the past that I've seen. Lisa, I don't know that we've been able to speak together before, but I'm looking forward to it. And do you want to say hi to everybody?
Good afternoon, everybody. How are you? I hope you're doing well and enjoying the sunshine. I have some coming in. I hope there's not glare on. There's a little bit of glare up here, so hopefully that doesn't move forward, but it's nice to have the sun out today.
Yes, it's a sunny day in November. If anybody's watching this in July, they will be confused, and that's how YouTube works. Along with Lisa today, we have Katie Perry from our Scranton office. Katie has actually been on our video series before, so I can speak with firsthand knowledge. She does an excellent job. I know our clients in Scranton really speak highly of her assistance, her skills on their cases. Katie, can you say hi to everybody?
Hi, everybody. Thank you for coming.
Okay, so all three of us, in the event you were confused, we are all specialists. We practice, if not exclusively, primarily Pennsylvania workers' compensation law, defending insurance carriers and employers. So if you don't know us, which I think most of the people I see on the list probably do, but if you don't, that's what we do. What are we going to talk about today? Just to bring you up to speed quickly, we're doing this overview series. So far, we've covered Pennsylvania workers' compensation forms. That was the most boring one. So if you really need to get some sleep, go on YouTube, watch the forms presentation. It's important stuff, but it can be tough to get through. We went through course and scope of an employment. What employees or what people who think they're employees might be someone that you need to be concerned about having a workers' compensation claim in Pennsylvania. We also went through claim petitions. What is the burden of proof on the claim petition? And what do you do to try to defend a claim petition? So that brings us up to today. And today, the world we're living in is a world where we have an accepted injury. You picked up that injury using the proper form that we told you about. Maybe it was an NCP, it was a TNCP. You already accepted the injury. Or we have an adjudicated injury, which is where a judge said, I know you didn't want to accept that injury, but I'm going to nail you with it anyways. So we're working with a world where the claim has already been accepted. You have an exposure. In some cases, you might have a medical exposure initially that becomes a wage loss exposure, or in many cases, you'll have it, on both sides. You'll have the medical and the wage loss. I like to look at wage loss when I discuss it with clients and others as a situation where you try to control the controllables. And what I mean by that is when we talk at our next series in January about medical, I think everybody will agree that medical exposure can be very unwieldy. And a claim that doesn't have a lot on the wage loss side could really get tough on the medical side with exposure. Conversely, in my opinion, I think that with wage loss, while it can be costly, there's a limited and defined tool chest that you have to deal with wage loss on your claims. So that's what we're going to go through today. We're going to go through the different ways that you can act on your claims to try to close out that wage loss exposure. And just to do the old tell them what you're going to tell them before you tell them, we're going to talk about full recovery termination petitions. We're going to talk about job offers, offering a job to the injured worker. We're going to go over the concept of earning power. If you can't offer a job, can you prove earning power? Can you prove that the claimant shouldn't be getting as much wage loss benefits as they are? We're going to talk maybe briefly, hopefully briefly, about impairment rating evaluations and how they apply to wage loss in Pennsylvania. And then we're going to wrap up with settlement. Throughout that, we're going to take your questions. If you have any questions we didn't get to, we'll probably circle back around them at the end. So that is my always too long, brief introduction, Lisa. I think you were going to start with termination petitions.
Yes. So as we know in Pennsylvania, an injured worker is theoretically entitled to ongoing wage loss and medical benefits, in some cases for life. So one way, the first way we're going to talk about to mitigate the ongoing wage loss is through what we call a petition to terminate benefits. This is kind of the golden goose for Pennsylvania workers' comp. And in order to file a petition to terminate, to cut off not only wage loss benefits, but also medical benefits, is to obtain a full recovery opinion from a medical expert. So typically this is done through an independent medical evaluation. This is set up either through the claims adjuster or through the attorney's offices or through a vendor. And you want to try to find the most appropriate medical expert, first of all. If you have orthopedic injuries, you want to get an orthopedic expert. If you have a neurological injury, you want to get a neurosurgeon or possibly just a neurologist to perform the independent medical evaluation. You want to send all of the medical records if you can. If you have the MRI films, that's fantastic. We always like to see our medical experts actually review the films, which makes their opinions more credible if you get in front of a judge and you have to actually take their deposition and go to decision. So we need to get our medical expert to not only say that the claimant is fully recovered from the accepted work injuries, but also that they don't need any further treatment in connection with that work injury, and that they're able to go back to work in their pre-injury capacity and or position. So one thing to be aware of is that we need that medical expert opinion of full recovery to address all of the accepted injuries. This would be those that are in the NCP, which is a notice of compensation payable, or the TNCP, which is a temporary notice of compensation payable. And as Jason mentioned, in the decision, if there is one, a judge oftentimes will expand a description of injury. So you need to make sure that your medical expert gives a full recovery opinion in connection with all of those injuries. And then after we have that, then we can file the petition to terminate. Now, please keep in mind in Pennsylvania, the burden of proof is very high on petitions to terminate. Judges oftentimes are reluctant to find people fully recovered for a variety of different reasons. It might be they have a long employment history, or maybe their age, or it could be any sort of circumstances, which leads us to the second method of mitigating the ongoing wage loss on a particular claim, and that is through a job offer. Now,
and Lisa, just before we
yes,
start with job offers on termination petitions, I think in my cases, I feel like they're the easiest to understand conceptually. I think they're probably, I think termination is an evil misnomer, and it might be one of the reasons that judges are hesitant to grant the relief requested. It sounds like you're murdering someone. But I think that I'm interested in your experience. I think out of the remedies we're going to discuss today, winning the termination petition might be the least likely.
Yes. I think the job offers that we're going to get into, your chances of being successful in connection with a petition to suspend or modify based on a job offer is higher, in my opinion and in my experience in Pennsylvania in particular, versus being successful on a termination petition. And how about you, Caitlin? Would you agree with that?
I would agree. With the termination, you have to prove all disability is ceased, whereas with a job offer, you just have to show that the claimant's capable of working in some capacity. So I think that's definitely accurate.
And then the only other thing I jotted down while you were discussing termination petitions, Lisa, was in discussing selection of a medical expert. The one thing that I think all three of us I've seen do, and I know a lot of attorneys out there try to do, is select the right medical expert, but also have, as much as you can, an open line of communication with that medical expert. And when you send them the job offer, when you send them the past medical records, if they don't address something in that report, I've found the easiest thing to do is to go back and write them a letter and get an addendum, or just get them on the phone and have a discussion. And if they're reluctant to do that after they initial their initial report, if Dr. Smith says, I said what I said, and that's my opinion, then I'll tell you that they're probably not going to be a good expert for you on that claim. You really want an expert who's going to consider what you're asking them to do. You don't need them to change their opinion, but I think you need somebody who's going to take into account what you're putting before them to tailor the expert opinion to the actual facts of the claim. But let's move on to job offers. I think that's a fun one. What do we have for job offers in Pennsylvania? When do they become an issue, and what do you recommend for clients?
Well, going back to the full recovery opinion from our medical expert, something I will typically suggest if the insured is agreeable is to also have a full duty job offer extended to the claimant, because while a judge might not be ready to terminate benefits because they feel that somebody might need some more medical treatment, they may be more willing to grant a suspension based on a job offer. For example, if you have an injured worker who works as a cashier, well, maybe they might need some more treatment. Let's say if they had lumbar surgery, but the judge can certainly believe that they're able to go back to work in their pre-injury capacity as a cashier because they can sit and stand as needed. The position is just more, it's easier for the judge to find that somebody can go back to work, which is why, you'll see attorneys suggesting that a full duty job offer be extended in connection with filing the petition to terminate. So the other option is, let's say if we have our independent medical evaluator that gives us restrictions, or we have a claimant that is still treating with a panel physician, and you get restrictions from your panel physician, then what are you going to do at that point in time? The most prudent thing to do is to talk to the insured and see if they're willing to accommodate those restrictions, and make a modified duty job offer or a sedentary, depending upon the restrictions that we get from the physician. And we want to do that as quickly as we can once we get that medical release. It's hot off the iron, we're ready to go. We also would like to see, if possible, that the claims adjuster issue the notice of ability to return to work, or that you provide the light duty release quickly to your attorney, so that your attorney can then file the notice of the ability to return to work, which is often a prerequisite when you're pursuing a petition to modify or suspend based on a job offer. I should say that if the treating physician discusses those restrictions with the injured worker at the time, that the notice of the ability to return to work is not required. However, I should caution you that by the time a claim were to get into litigation, let's say based on a job offer that was made with those restrictions that the doctor reviewed with the injured worker at the time, we often find when we take the deposition or the testimony of the injured worker that they don't remember discussing those restrictions with their treating physician, in which case it then becomes incumbent upon us to show that the notice of the ability to return to work, the 757, was in fact issued, so that we can get a judge to grant a petition to suspend or modify. That's a little bit more technical than we might need to hear today. But once we get those restrictions, if we can contact the insured and they're willing to accommodate those restrictions, let's get that job offer out there. Let's, if we can, include the hourly rate, the shift, the title of the job that's being offered, if possible, the restrictions that were provided, to enclose all of that within the body of your job offer letter. You also want to make sure you have a return to work date that's within a reasonable time frame. In other words, give somebody more than 5 days to respond to the job offer, especially in today's world where there seems to be a lot of issues with the mail. So you want to give them at least 7 to 14 days to respond to a job offer. Give them the contact information for who they should get in touch with at the insured regarding the return to work, and get that out in the mail as quickly as possible. Something you also should keep in mind too is that if you have an injured worker that is represented, you should copy their attorney on that job offer letter as well. So let's say you get that job offer letter out there. If you can, include the job description. If you can't, then try to narratively describe what that position is within the job offer letter. Let's say your injured worker comes back to work. Well, then you should file a notice of suspension within 7 days of them coming back to work, and that will automatically suspend their benefits. They do have options to challenge that, after you file that notice of suspension, but at least you have that filed, which means that now that NCP or that TNCP is closed and you have this notice of suspension in place, which is great for you to have on your claim. And then it kind of converts your claim from a wage loss and medical to just a medical only claim. And then you can focus on addressing the medical and dealing with that. Now, if an injured worker does not come back to work, the next step would be to contact your attorney, let us know that, and then we can file a petition to suspend or a petition to modify based on the job offer that was extended. And then once that gets filed, it goes into litigation, and then you get some leverage for settlement as well. But like I said, a job offer from the insured, I think, is one of the best ways to try to mitigate the ongoing wage loss exposure on your claim. The judge will look at the job offer letter. It puts the employer in a good light because they're trying to do everything that they can to accommodate the restrictions of the injured worker. They gave a reasonable time frame for somebody to come back to work. You're willing to work with them with those restrictions, and judges are oftentimes much more willing to accept that than just a full recovery petition.
Yeah,
Jason,
Lisa, I
did I miss anything?
think, no, I think we discussed it already in a prior seminar about claim petitions, burden of claim petitions, defenses, probably more so defenses to claim petitions. And I think Lisa actually mentioned it as well. A job offer can come at any stage in the claim. So we preface this by saying you're already locked into your exposure by a decision or by NCP, TNCP. You can make a job offer a day after a work injury. And oftentimes that's the best way to avoid wage loss, because you might get that worker back in that workplace, even though they're injured. I'm not saying people don't get injured that, have workers' comp claims. What I'm saying is there's people that are injured that are treating that are still able to work. There's a joke in there somewhere, but you can get them back to work so that you never have to worry about the wage loss aspect of the claim, at least for the foreseeable future. Doesn't always happen. You have to have a good workplace, return to work system set up. But I think that that's one thing we talked about in a prior seminar that would apply here. The other thing, and I'm interested in, but both of you guys have any, I don't want to say horror stories, but warnings about job offers. One thing I've seen with a couple of our larger employer clients is I think communication is very important, because you'll have somebody who's in the risk manager role or a claims manager who's handling this job offer. They put the job offer letter together, talking to a supervisor. Injured worker comes back to work that day. They show up on the day they were told to show up. They talk to somebody else, and the somebody else says, well, you don't have a full duty release. You don't have a full duty release from our panel. Therefore, we can't let you work today. And I've unfortunately had this happen on several claims where the claimant testifies and, they're asked, did you try to come back to work? And they say, yeah, I did. And Bob over in receiving told me I didn't have the right letter from work health, so I need to go home. So I think the only way you can address that is to have open communication between your TPA, your adjuster, your people at the employer side, claims managers, all the way down through, so that everybody knows, workers coming back on Thursday, here's their release, here's what they can do. Because when you've gone to all that effort to set all that up, you don't want it to be tripped up just because somebody honestly didn't know this was happening, or they weren't aware that this was going to be, this worker was coming in today. Do you guys have any others that you've encountered where you think it might be something to be mindful of with job offer letters?
I think one thing that I've seen is language in a job offer letter that I caution against, and that's the use of temporary position. We have a temporary position available for you. It lends to the thought that this light duty position is only going to be extended for 30 days, 60 days, or 90 days, which is problematic on our end, because once it gets into litigation, it raises red flags. And I've had a judge do this where they've only suspended for 90 days because it was a temporary position versus, just leaving that word out. Because lots of times these cases settle anyway before you get to the end. So it's a non-issue, but when you have that word in there, then all of a sudden, you're only arguing a suspension for a short period of time versus having the leverage of getting a full suspension that's ongoing. So that's one thing I would caution everybody against using temporary in their job offer letters. And also too, is that positions, we're trying to get people to come back to work after their work injury. We don't want them to necessarily get comfortable being at home, not working, and get almost accustomed to that lifestyle. We want to bring them back as soon as we can, because the chances of them then, transitioning back into full duty is higher because they're already coming back to work. They didn't miss significant amounts of time from work, so it's easier to roll over and get them to go back to work. And then you never have to deal with the actual, accepting a wage loss claim. And it could be nonsense kind of a job, it's just to get them in the door, back to work, doing, sorting papers or whatever, might be available, and then you're going to transition that person as they continue to get better, and you're getting, less restrictions from the panel physicians. But, sometimes we see that makes a big difference versus, having them stay at home for 6 months and then trying to get them back to work. I think claimants are just more reluctant, and they become accustomed to staying at home at that point.
Sure. Katie, did you have anything on job offer letters before we move on?
Just practically speaking, I know we're always happy to review them for the employer, just because sometimes, like Lisa said, there could be little things in there that can really affect the litigation. Even if you don't add the specificities of a job when it's not their pre-injury job, and then they come in and testify, I didn't know what I was going to be doing. You can kind of head that off at the pass with just a nicely authored job offer, and we're always happy to look at them.
Yeah, and for the employers who are participating today, I think my best words of wisdom on job offers would be to think it through and make sure that we're aware of the reality that sometimes an injured worker goes out that you don't want to come back to work. So you need to recognize the reality that if you offer the job, and you can sometimes tell by the employee, you might know that when you offer this employee the chance to come back, they're never going to come back. But sometimes they do. So, and that might bring somebody back into the workforce that you weren't planning on having in the workforce. So if that's your goal, if your goal is to, move on from this situation, then be cognizable of that while you're making the job offer. The flip side of that is, and it's what Katie's going to get into in the next section, if you have that job available and you don't make the job offer, you as the employer, your insurance carrier, your adjuster need to be cognizant of the fact that you might be foreclosing on other things that you can do moving forward in the claim. So if you have a job open and you don't offer it for whatever reason, then that might make it harder for us to prove some of the stuff we're going to talk about coming up in the next section. Anybody else have anything on job offers? We're good? Okay. Katie, I think we're next going to talk about a situation in which either the job offer doesn't apply, you can't make a job offer, it's not a situation where a job offer letter is coming into play. There's other ways that we can prove that a claimant has earning power. We're talking about labor market surveys, imputed earnings analysis, that sort of thing. Can we start with labor market surveys? What's our basis in the act for going down that road, and what does that mean, a labor market survey?
Sure. So in 1996, there was an amendment to the Act under 306B that provided a somewhat easier way, as opposed to an actual job offer, to prove earning power. Before you embark down the labor market survey route, two things need to be true, one of which you just mentioned, Jason, is there cannot be work available at the pre-injury employer within the claimant's current physical capabilities. So if there is, you're precluded from going down this route because you need to present evidence that there's no work available. Secondly, you need a medical release of some sort, whether it's sedentary, light duty, a doctor, whether it's the IME physician or the treating physician needs to have released claimant to work in some capacity. With regard to that, as Lisa mentioned before, it's very, very, very important to issue the notice of ability to return to work. As soon as you get that medical clearance, issue it or tell us and we will issue it, because that is a prerequisite for many things, including a labor market survey. So if both those things are true, they're released, the notice of ability to return to work has been issued, and there's no work at the pre-injury employer, you can go down the labor market survey route. And to do that, you would refer the case to a vocational expert. There is a chapter of the Bureau Regulations 123, which talks about who qualifies as a vocational expert under the Act. So a lot of the times we have certain people that we've used before that we refer the case to that have been qualified as vocational experts hundreds of times. So that's another way to do it. Lisa talked earlier about job offers. If you're going down the route of a labor market survey and trying to prove earning capacity through this route, the actual job offer requirement, you don't need to meet that. The way that you prove earning power is through the vocational expert, through their opinion evidence that the claimant has earning power and they're capable of working in the local labor market. So in order to do that, what the vocational expert does is conduct what's called a labor market survey, and they find jobs. And it's important to keep in mind that they have to find actual jobs. They have to be open and potentially available to the claimant. And the courts have talked about that. What does that mean? Open and potentially available. Basically, the claimant just needs to be given an opportunity to apply. So if you're litigating a labor market survey, it's important to ask the vocational expert, was this open? Not just at the time that you conducted it, but did you follow up? Was it open later? The courts have said that a claimant can come in and they can testify that they applied for all, 5 jobs that a vocational expert identified, and they didn't get any of them. The courts have said that's not dispositive, that they lack any earning capacity. It's relevant, it's admissible, but it's not dispositive. On the other hand, if they come in and say, I applied for one of the jobs, the job was filled, that job doesn't exist for purposes of a labor market survey and to assess the earning capacity of that particular claimant.
Katie, when I broke into the practice, there was a lot of talk about the Kaczynski standard and the quote unquote Kaczynski job offer. And my understanding is that's a little bit different than what you're talking about with the labor market survey. Can you explain, how do those things fit together? Are people still doing Kaczynski job analyses?
Sure. So the Kaczynski job analysis would apply to what Lisa talked about in terms of offering an actual job at the pre-injury employer, or say a vocational expert actually finds jobs and you refer them to an actual job, you would engage in the Kaczynski analysis, which again was talked about, and it's a 1987 PA Supreme Court case. So when the legislator passed 306B, the courts interpreted that to not require that Kaczynski kind of doctrine and the outline that you have to go through. It didn't overrule it. It's just a different inquiry. And again, it's a little bit easier because you don't have to show there's an actual job out here. They were referred for the actual job. You just have to show they have meaningful employment opportunities is what the courts have said.
And then I know you're familiar with this, and some of the people on the conference might be aware as well. And I don't have the year and pre-COVID and post-COVID, my mind is mush, but I know this was pre-COVID. the Phoenixville Hospital case came out, I'll just say 5 years ago. I have no idea when it was. We'll say it was 5 years ago. The Phoenixville Hospital decision came out. And for about 6 months, everybody freaked out and we all had seminars and we talked about the new standard of Phoenixville Hospital and how it is perhaps going to change how we do labor market surveys, how we deal with vocational evidence in trying to prove earning power. Has that played out for you? Can you explain to people, what did Phoenixville Hospital say just in general, and how have you seen that in your caseload?
Sure. It was 2013, I believe,
man.
Phoenixville. Phoenixville Hospital. But basically the court in that case really just talked about what is a meaningful employment opportunity, and what is substantial gainful employment. It can't just be that there's jobs out there that the claimant, is physically capable of performing. There has to be actual jobs that the vocational expert has identified that the claimant is vocationally capable and physically capable of performing. And with regard to that, the claimant is permitted to say, well, I did apply for this job, I didn't get it. And that's admissible, but the courts have said it's not dispositive. That doesn't mean that they lack earning capacity. I think it's a case-by-case situation for the judges to decide. Something the court talks about in both Kaczynski and Phoenixville Hospital is just the good faith inquiry. Did the employer make a job offer in good faith, or did the vocational expert find suitable work in good faith, and did the claimant in turn make a good faith effort to either apply, to try to do the job, to return to work? So I think the courts always take that into consideration when making a decision. Something I just wanted to touch based in the current climate is that I think labor market surveys may be more appealing now, just because with COVID, there's a lot more job opportunities. I think everyone can say that they've seen, ads, for either work, in person or work from home. And I think that could really help in terms of proving earning capacity, because even a claimant who, may not have a lot of background in computers or word processing, I've seen jobs advertised where it's work from home. So, hey, you have this person who's been released in a sedentary duty capacity. So they're working from home. They're going to try to say, well, I don't have computer skills to do this. But then your vocational expert could say, well, wait, they offer training. They come and set up the systems. So I think it's maybe more appealing now to go down the labor market survey route than it was in the past.
Yeah, Katie, you mentioned when you say computer skills in the labor market survey discussion, and my apologies to any claimants, vocational experts who are in the conference, you'll need to put on your earmuffs, but you will never find someone with less computer skills than a claimant who's been subjected to a labor market survey. It's almost insulting, and I'll get off my soapbox, but it's almost insulting what some of the vocational experts will say a relatively intelligent person can't do with a computer or with a phone when you're trying to find them a job in the labor market. Lisa, just to give it some context, have you seen the practice change since Phoenixville Hospital? Have you seen it been a big burden in presenting evidence on labor market surveys? I don't remember, I thought it was 5 years ago, it was 8 years ago, but I remember there was concern that it would really start to affect how we're presenting evidence. And I think in practice, I'm probably just saying, well, Mr. or Mrs. Vocational Expert, were these jobs all open and readily available? And they'll say, yes. And then I'll say, but were they really available? And they'll say, yes. And we've met our burden. Am I just being ham-fisted with it, or has it changed your practice at all?
No, practically speaking, in litigation, I've seen no change. There's no change. We're asking the same types of questions. It's, I think, more or less a legal type of a fiction that really never came to fruition as far as how to take the evidence and what the judges are looking at. There's really been no practical change.
Yeah, that's been my experience. Katie, I know we want to talk briefly about imputed earnings. before we do, some of the things that I wrote down while you were talking about labor market
Jason,
surveys. Yes,
real
ma'am.
quick before we jump on, I just wanted to say that I agree with Caitlin as far as labor market surveys in today's climate. I've spoken with several judges who all seem to be much more agreeable to and willing to suspend benefits based on a labor market survey versus 2 years ago or even 5 years ago. I think that labor market surveys are gaining momentum in Pennsylvania, and it's definitely something that should be considered. Whereas in the past, it was, very much the weakest petition to file and it really led nowhere. I think in today's environment, it really does help the case and does provide leverage when it comes to settlement.
Excellent. Yeah, I agree. And what I had written down touches on that. I'm going to make the attorney mistake of asking the question I don't know the answer to. I don't think any of us know the answer to. I agree that there's a more of a thriving job market. There's more jobs that should be accessible to someone who's injured, including work from home jobs. They don't have incredible physical requirements. Two issues that I foresee will pop up in case law. Maybe they have, and I haven't read the decisions yet. Vaccination requirements. If you're doing a labor market survey, do you need to consider whether the claimant has been vaccinated and whether the jobs you're saying are open and available require vaccination? Is that job really open and available if the claimant refuses to get vaccinated? We're not going to talk about that at all. Number two, medical marijuana. And we haven't touched much on medical marijuana during this series. That came out in 2016. I do know one date. And it's an ever evolving area of Pennsylvania law. It's an evolving area of Pennsylvania workers' compensation law. Issue obviously being, if you have somebody who's taking medical marijuana for a work-related injury, and there's certain employers on your list from the labor market survey of jobs that are quote unquote open and available, if those employers prohibit employees from using medical marijuana or using marijuana during the course and scope of their employment, are those jobs really open and available? Not something I would recommend you spend a lot of time on when you're setting up your labor market survey, but it's something that I could see coming up as a response to these petitions. Anything else before Katie, I think, is going to give us a little bit on imputed earnings assessment? Anything else on labor market surveys, either Kaczynski or the new blood type? No.
The only other thing I just wanted to say is that you could do both. You could have the vocational expert find a specific job and refer the person to that job in addition to performing the labor market survey. They're not mutually exclusive. So you can do both. That way you have a better chance of limiting liability at the end of the day.
A good question. And I had not checked in on the questions. I apologize. I'm just getting caught up now. There was an excellent question from, I want to identify the person. They wanted to know if we could see them. And we could see whether they're eating lunch or their dog's barking in the background. We cannot see you guys. I wish we could. I would love that, because everybody that's been living in the Zoom world knows how uncomfortable it is just to stare at these cameras and not have any people reflect and laugh at my bad jokes. But to that person, no, we can't see you. So you go wild, you slurp your soup, all is good. As to the topic at hand, we had a question about, I assume it's referring to the labor market survey. The question is, does the available job, and I use the term open and available jobs, does it have to be in the claimant's field of expertise? So if our injured worker is a dentist, can we use a Home Depot job as one of the jobs on the labor market survey list? Katie, can you address that?
Sure. So the job just has to be vocationally suitable. So that's why the vocational expert does an interview with the person and asks about their education, their background, their skill set. So it doesn't necessarily have to be, in the example you used, a dentist, them referring them for dental positions. I believe Chris had a case where the person was he was a mechanic or he in maintenance at a facility, and a labor market survey was it was a specific job offer at the pre-injury employer, and that was for a secretarial position. So that was not obviously within his expertise, but based on his background, it was vocationally suitable. That's not a labor market survey example, but I think the same holds true. If the expert's going to say, although this person performed job A in the past, he could perform job B that's within his capabilities vocationally, I think that meets the burden.
Yeah.
And Caitlin, when you I was going to say, when you say vocational background, the vocational expert is looking at someone's educational history, their prior work history, any skills or certificates that they may have obtained, in their adult career since high school, as well as any information that they learned during the vocational interview. So they look at all of that, and then they see if these positions, would qualify for somebody that has, that type of a background. So if you have a dentist, I mean, they typically are going to be able to handle a position over at Home Depot. So you'll meet that burden of proof, quite easily, I think, in that particular case.
Yeah, it was a
Absolutely.
good question. So thanks for the question. One thing that popped into my brain while you guys were talking is, of course, completely unrelated to that question, but something I wanted to mention previously and get both of your input. When we're talking about labor market survey, we're doing that based on medical evidence, typically an IME. I like to ask the vocational expert to aim for jobs that fall below the restrictions given by the IME doctor. So if the IME doctor says, claimant can lift 40 pounds over their head with their finger, I usually ask the vocational expert to take it a step below. If it's medium duty, see if you can find something in light duty. I found that makes for an easier presentation of evidence. I think it sells better to the judge. And you can always get the IME doctor who said the claimant's fully recovered to agree that you're saying the claimant's fully recovered. You'll agree that the claimant can work light duty, right? The IME doctor will give you that. And occasionally you'll get a treating doctor who will do that. And then you're fighting about, can the claimant use a computer and the vocational things that we've talked about. Have you guys seen that work in any of your cases? Do you do that ever? And, how has that played out?
I think that's great. If you have an IME doctor saying that the person can do light to sedentary duty, obviously, and you also have the treating physician who's released them in some capacity, whether even if it's sedentary duty, and the vocational expert identifies a certain amount of jobs within the own treating doctor's restrictions, I think your chances of success are even higher. So I think that's smart to say to the vocational expert, identify light duty down or whatever, just, not within just the IME physician's release, but also the treating doctor's release.
Cool.
And I would say I had one case, actually, I think I had two cases where I've been able to do this, where I had, was litigating a termination petition, full recovery opinion. Claimant's medical expert testified and testified that the claimant could return to work, not full duty, but with some restrictions. And then with further cross-examination, we were able to really drill down on what exactly those restrictions were. Then we issued a notice of the ability to return to work with the doctor's deposition testimony attached to it. And then we referred it out to a vocational expert who went out and found different positions using a labor market survey based on the claimant's own treating physician. And then we were able to settle the case very quickly for a great amount of money. So, if you kind of think out of the box and just keep these tools available to you, and keep an open mind, there's lots of different ways that you can use, these different types of tools.
Yeah, and settling for a great amount of money in this context, Lisa, was not very much, I'm assuming, hopefully.
Correct. Yes. Yeah.
The other thing that I had written down just now was when you're doing this, when you're trying to tailor your labor market survey to what the claimant can do physically, and I always, on a claim petition, I always ask the claimant when they say, I can never work again, I'm totally disabled for life from this job, from my job as a forklift operator. Well, do you think you could work at all? What do you think you could do? Could you sit behind a desk and type on a computer? You're going to get objections. It's irrelevant to the claim petition, blah, 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 blah. You now have that testimony. You can use that testimony in the future. You can go to your labor market survey, say, claimant Bob testified that he can't do his heavy duty job, but he could sit at a desk and type with one finger. And that can be utilized as well. What you're trying to do is you're trying to show the judge that you went to all lengths, you did everything you could to tailor these jobs that you located in the community to what this person can actually do. And if we're doing these more, and I agree with both Katie and Lisa that I think we're going to see more labor market surveys, it behooves you to do it the right way. So I think all of these things play into that. Imputed earnings, Katie, can you just give us a quick overview?
Sure. Yeah, we just wanted to touch base on imputed earnings. It's another way you can use a vocational expert. For instance, if a claimant is self-employed and there's no proof of actual earnings, you can use an expert to come in and testify and say a similarly situated person in the community, for instance, if you're self-employed as a mechanic or something of that nature, makes this much per year. So that way you can prove earning power even without actual earnings.
Excellent. So let's do this. We're getting a lot of good questions coming in, and I want to dedicate some time to them. I want to make sure we get through our content first. So let's move ahead, if we could, to, I've got 15 windows open here. Lisa, you told us you were going to recap the last 6 years of Supreme Court decisions on IREs in Pennsylvania and the legislative changes and all of that. You can do that in like 5 minutes, right?
Yeah, sure. Nobody wants to hear all of that. I'm positive, Jason. What I will do is just a quick recap on impairment rating evaluations. This is an exam that you can request after a claimant has received 104 weeks of temporary total disability benefits. Those are the wage loss that's being paid out on an accepted claim. The reason why you would want to get an impairment rating evaluation, which we call an IRE, is because it creates a legal fiction where it converts the temporary total disability benefits to temporary partial disability benefits. And under the Pennsylvania Workers' Compensation Act, temporary partial disability benefits are limited to 500 weeks, which is slightly over 9.5 years of wage loss benefits. So rather than having a possible lifetime exposure of ongoing temporary total disability benefits, you would want to try to convert that and cap it to 500 weeks through the IRE process. And that process entails, once a claimant reaches 104 weeks of temporary total disability benefits, you request through WICAS an impairment rating evaluation designation. And it's a form that you upload on the claim in WICAS, and then the Bureau assigns a physician who's qualified to perform these exams through the Department of Labor to the claim, and then they perform the evaluation. And then they render an opinion as to whether or not the injured worker has a whole person impairment of 35% or less. If they come in less than the 35%, then you can get that conversion to temporary partial disability benefits and cap them at the 500 weeks. If it comes back higher than the 35%, then you're in trouble. So it's another tool in the shed that you can use to try to cap the ongoing wage loss benefits. There's been some, as Jason suggested, some litigation regarding them and whether or not they're constitutional. Right now, there are certain law firms in the Philadelphia area who advise their claimants or injured workers to not attend the IRE, and then we have to file a petition to compel, and then we get in front of a judge and we request the order to compel them to attend the IRE, and then claimants' counsels are preserving their rights so that they can appeal the IRE should we get future case law finding them unconstitutional. So in a nutshell, that's your IRE. It's nobody likes to see an IRE. That means that your claim is open and there is, potentially that ongoing wage loss exposure, and so hopefully we can mitigate your exposure before we get to the IRE, which would be great.
Yeah, that was excellent. I think it's a protective measure. It's make up a metaphor as we go. If you're buying a new house, you want to make sure you have a fire extinguisher. And I look at the IRE, that's your fire extinguisher. That's your safety measure. If all goes wrong, you still don't want your house to burn down in the meantime because you got the fancy fire extinguisher. So you have that to fall back on, but you really don't want your claim to extend out 500 weeks. I think everybody participating knows that you want to shut it down before then, but this is still a prudent thing to do. And Lisa did a good job explaining how it works. And, it's been up in the air the last couple of years, but as of today, it's still a measure that exists and it's something to be aware of. Katie, anything on IREs, or are we good to move on?
Lisa covered it.
All right. So if you don't want to do the IRE, if you're in bad shape when you got to the IRE, Katie wants to settle your case. She's going to ask you for a bunch of money to settle it out. So what are we talking about there? How's that going to be a tool? It sounds like we're giving up. What's the approach?
So I think just to touch base on everything that we've talked about so far, is a way to gain leverage in order to settle the case, which is another way to limit your indemnity exposure. Ideally, we would like to settle medical and indemnity at once, but if that's not possible for whatever reason, you can just settle indemnity benefits. And something to be aware of is that if we decide to go down that route, what you could do is just add specific language in the settlement agreement that the injury can't be expanded or changed in the future. So that way, going forward, you're not going to be liable for additional medical bills for something that wasn't included when you settled the wage loss. So that's something to keep in mind. Some situations where it makes sense to try to settle just the indemnity benefits are if an MSA is required and if CMS approval has not come through and it's taking forever and you just want to cut off wage loss ASAP, you can decide on a number to settle the indemnity benefits and have a hearing before the judge to approve that. There's two different ways you could do it. You could do it as just indemnity only and then do a separate agreement once CMS approval comes through for the medical benefits, or depending on the judge, you could settle everything at once and put language in the agreement that the MSA proposal is this much. We're waiting for CMS approval. Once it comes through, medicals will automatically close. And I would also add language in there that if CMS approval comes through and the number is way higher than you expected, you reserve the right to just keep medical benefits open and administer the claim just medically. Again, that depends on the judge if they'll let you do that. Another scenario where you may just want to settle your indemnity benefits is if the claimant is insistent upon a period of open medical, 3 months, 6 months, 9 months, and they're not budging. Obviously, we try to have them close everything at once, but in order to just cut off indemnity ASAP, you could say, okay, well, we'll agree to have medicals automatically close on X date. And again, do the agreement that they just close at that point. It's another negotiating tool. If they come to you and say, I want this amount of money and 12 months of open medicals, we try to negotiate them down and try to get it as low as possible. And again, if they won't budge, it's a way to kind of limit your liability sooner rather than later on the indemnity side of it.
Excellent. Yeah, I think it's probably a tool that's not used a lot, but it's still a tool. One question I did have, and some of the people on the call might be familiar with this instance. There's sometimes a thought that if you settle the wage loss and you give the claimant a lump sum, they'll stop treating and the medical exposure will kind of go away on its own. How has that played out for you guys? Is that something that you see, or is it something that you could, maybe get into trouble with?
I've seen it turn out both ways. I've seen the medical dwindle, and then I've also seen claimants that have continued to treat, for the next 5 to 10 years. And then, we're stuck doing URs to try to minimize the ongoing treatment. And so I think you really need to know your claimant when you make that decision on whether or not you want to try to just settle indemnity, because sometimes, when you settle just the indemnity, you're losing one of your big hammers that you can use to negotiate a full settlement. And if you have a claimant who, for whatever reason, feels that they need to continue to treat, and sometimes it has nothing to do with the work injury. Sometimes they have, other issues that are going on, and they feel the need to continue to treat. I think it really behooves you to know what type of personality you're dealing with and what are the chances that they're going to continue to feel the need to treat, because I have seen it go in both directions, unfortunately.
How about for you, Katie? Similar experience?
I agree with Lisa. I think it's case by case. I think just settling indemnity isn't a guarantee that treatment's gonna trickle off and stop. I think it depends, and I don't know. I don't think that's a definite. Just because you settle the indemnity, they're going to kind of forget about their medical treatment. So
Yeah, I agree too. I think more than likely, the claimants that are going to stop treating are the ones that aren't going to help you very much. And if you have a claim with huge medical exposure and you're hoping that they'll stop treating, hope isn't always a great game plan. So I think what both Lisa and Katie said, you really need to know your claimant and know what you're getting into, because you don't want to be settling the case with a huge lump sum twice just to get out of the medical, a year or two later. We were going to talk about supersedious. I think we're actually doing that in a subsequent seminar as well. So I think if you guys are okay with it, I'd like to get to the questions because there's a couple good questions. Hopefully we can get to them all. One was addressing job offer letters. And the question is essentially, does it have to be a certified letter? Do you have to send those job offer letter, certified receipt, post office documentation to make sure that it was received? You guys, one of you guys want to grab that one?
I think as case law stands right now, if you send out a job offer letter in first class mail and it does not come back as undelivered, then there's a presumption that the claimant received that job offer letter in the mail. I typically will send it first class mail and certified return receipt. And I send a copy to claimant's counsel as well if they're represented, and that way all the bases are covered. But if the claimant's not represented and you send it to his address and it's not returned as undeliverable, then there is a presumption that they did receive that job offer letter.
Another question, I guess, Katie, this is on labor market surveys. It's really a strategy question. The claimant is of retirement age, but she was injured prior to her retirement. Would you still do a labor market survey in that scenario? I think, yeah, I think that's what we're saying here is that the claimant is, right on the cusp of retirement. Perhaps they had planned for it. Is that still a situation that you can do a labor market survey because, the employers out there in the community might be unlikely to hire someone who's of that age? How does that play into labor market survey, someone's age or potential retirement status? Or does it at all?
I think, yeah, it's still worth it to do it. I mean, at the end of the day, the goal is to gain leverage to settle the case. I mean, I think it is a question of, like I talked about before, good faith. So I think that would come into play possibly if you got to litigating it. But I think as a tool to try to create leverage, I think it would still be worth it.
Yeah, I think labor market surveys, you'll get some fun responses on why a claimant is ineligible to work in the workforce. The most memorable that I have that for whatever reason we never uncovered ourselves during the litigation of the claim was I had a claimant who was also of retirement age who we tried to labor market survey. And at the hearing before the judge, after we had already presented the testimony of the vocational expert, the claimant's attorney said, "Is there any reason why you think you might not be employable within these jobs?" He said, "Well, I was convicted for murder and I spent a bunch of time in prison." And I said, "Well, you know what? That's pretty good." So you're going to find stuff out that you might not have known about the claim. So another good pointer is make sure you know your claimants well before you go down these roads. But I agree. I wouldn't take any of these factors, retirement age, criminal history, whatever. If you employed them, then somebody else can employ them. So you're still going to want to look at the labor market survey as an option if it's there for you. The question I'll take on. The question is, when a claim is officially denied, do you have to accommodate, which I assume means accommodate restrictions for the worker, or do you send it to your HR department that deals with ADA? This is not obviously human resources seminar, but from the comp standpoint, once you've denied that work injury, I don't believe the Workers' Compensation Act forces you to do any accommodations in the workforce. So if a claimant who works in the factory floor says, "I believe I have a work-related back injury," and you're pretty sure they hurt their back injury doing amateur professional wrestling over the weekend, you deny that injury, you can keep their job open because they're an employee, but I don't think you have to accommodate it from the workers' comp standpoint. My interpretation would be if they have a disability as defined in Pennsylvania or by the ADA, then you should talk to your HR department. Does that sound right, guys? Am I missing anything there?
No, I would agree, Jason.
Okay. I agree. We have a case like that now where they're not required to accommodate. In this case, they are, which I think, just brings some goodwill for this case. But yeah, you don't have to accommodate if it's in denied status.
another good question specific to a specific employee here, but I think it applies to, frankly, both job offers. If it was a job that's different than the original pre-injury job, and especially labor market survey, the issue of language barriers. So you're talking about an uneducated general labor who has a language barrier that would theoretically prevent them from doing office work. They're not qualified for any entry-level office work, and that's why they're in the factory job. Is a labor market survey in that scenario with that claimant a lost cause, or would you still consider it?
I think the answer remains the same. I would still consider it. Like you said, Jason, if they were employed by you, they're employable other places. So I think you could still consider it.
Yeah, and I think that you can tailor the labor market surveys, to meet your injured workers' needs. So if you have an injured worker, that only speaks Spanish, for example, then, your vocational expert is going to be looking for positions, where he's not required to, or he or she is not required to speak English. They can perform the position in their native language. So it's just, a lot of times, we really have to be specific with our vocational expert, with what this person is qualified to do and what type of positions, if there is a language barrier. And then it's that vocational expert's job to go out and find those types of positions, where, English is not a requirement, speaking English.
Yeah, I think, and we've touched on this a little bit, the vocational evidence realm of Pennsylvania workers' compensation is this weird area where an injured workers attorney is essentially arguing that the injured worker is incompetent, and we get to put on the hat of you can do anything you put your mind to, sort of thing. So it's an interesting situation, and I think in some instances that can be compelling for a judge. I think some judges will be offended if you're arguing that, this gentleman or lady that's sitting here in front of you, Your Honor, is completely incapable of doing anything. I think maybe it's the human experience, but people want to believe that other people have some capacity within them. So I wouldn't discount that when you're arguing it before a judge. We have a couple more questions, but I think they're very specific. They might be better followed up with emails. Did you guys have anything that we missed, or any other comments you wanted to get out on wage loss, getting rid of wage loss in Pennsylvania workers' compensation claims?
I think just to throw out there real quick, when it comes to medical experts, when you're scheduling your independent medical evaluations, to keep in mind, what the ultimate goal is, as far as that claim. Are you looking to settle the claim? Do you have a very difficult claimant who does not want to settle the claim, in which case you have to pay particular attention to what type of expert or which expert, because we all know that there are experts out there that are more likely to give us full recovery opinions, and then there are other experts out there who judges find more credible. And perhaps if you know that your case is going to go into litigation, you have a difficult claimant, you want to pick that medical expert that judges are going to find more credible. You might not get that full recovery opinion that you need, but you will likely get restrictions, in which case you can go down the route of doing a modified duty job offer. And then you might be actually more successful in front of a particular judge when you have a more credible expert and a modified duty job offer, versus an expert that's been around the block for many years and you're litigating a termination petition. So I would just keep that in mind, figure out what your ultimate goal is, and then make sure you get an expert tailored to meet that goal.
All right, Katie, any parting words or comments, jokes, anything like that?
No inappropriate jokes. No, I just think that's great advice, Lisa. I think that if your goal is leverage and getting the case to settle, sending a person to an expert who we all know has testified a million times, the judges all have heard before, it's really just a waste of money, and it's not getting you the actual leverage that you want. So I thought that was great advice.
Very good. Well, thank you everybody for joining us. As I said, this will be available online on our website, on our YouTube channel, and wherever else we might be present on the internet. And we'll be following this up January 20th, I believe, with the next session. So thank you again. We hope you all have a great Thanksgiving and holiday season.
Thank you, everybody.
Thank you. Thank you.